The Sexual Offences Against Children Act 2017 was introduced to address the seriousness of sexual offences committed against children in Malaysia. The ultimate goal of the proposed act is to provide for better protection for children against sexual offences and to safeguard the well-being and interests of children and to provide effective deterrence. The Sexual Offences Against Children Act 2017 was perhaps the fastest piece of legislation created and enforced into this country. The whole process, from tabling of a bill to its entry into force, took only 3 months. Malaysia's goal to protect its children extends to Section 3, which states about extraterritorial application where, if any offences under this Act or any offence specified in the schedule where the victim is a child is committed by a Malaysian citizen against any child in a place outside Malaysia, he may be dealt with in respect of such offence as if the offence was committed at any place within Malaysia. In Malaysia, a child is defined by the Child Act 2001, where a child is a person under the age of 18 years. The main areas addressed in the bill are firstly child pornography, which anything that actually amounts to child pornography is laid down in Section 4 to Section 10 of the Act, which is concerned in production, distribution, viewing of child pornography. Child pornography is defined in Section 4, subsection A, where it states, child pornography means any representation, whether visual, audio, or written, or the combination of visual, audio, or written. Section 5 prohibits any form of involvement in the making of child pornography, while Section 7 prohibits using a child to produce child pornography. Section 8 is about the distribution and reproduction of child pornography, and Section 10 is about accessing or watching child pornography. Secondly, child grooming. Child grooming occurs when an adult befriends a child and creates an emotional connection with the intent to sexually abuse the child. This is broken up into 3 sections, roughly summarized as communication, grooming, and meeting in person. Section 11 prohibits any form of sexual communication with a child or encouraging a child to have a sexual communication. However, subsection 3 states that an exemption is made if the communication was for the purpose of science, medicine, or education. Section 12 makes it illegal to communicate or pretend to be someone else to sexually communicate with a child. Section 13 describes the situation where the adult actually meets up with a child. Thirdly, sexual assault, whether it is physical or non-physical. Section 14 covers sexual assault on minors, which involves not just touching a child but also in getting a child to touch you. There is a clear distinction between merely touching a child and touching a child for sexual purposes. With regards to non-physical sexual assault of children, these are highlighted in Section 15. Basically, non-physical sexual assault is where an adult exposes a child to sexual or indecent situation. Lastly and fourthly, abuse of position of trust. Section 16 of the Sexual Offences Against Children's Act allows the court to sentence someone who is in a position of trust with the victim up to 5 years in prison and at least 2 strokes of cane on top of whatever punishment had already been given to them. To add perspective into how this law applies, let's say a stranger who sexually assaults a child would be guilty of it under Section 14. However, a teacher sexually assaulted a student, the teacher would be guilty of an offence under Section 14 and offence under Section 16.
Singapore and Malaysia share the same history. In Singapore, the age of majority applicable is 21 years old as provided by the common law. However, the definition of child can be defined differently stated of various legislation for specific purposes. According to the Child and Young Person Act 2001, a child is a person below the age of 14. A young person means a person who is 14 years of age and above but below the age of 16 years old. The Women's Charter 1997 defines a child as a child of the marriage who is below 21 years and a minor as a person who is below the age of 21 years and who is not married or a widower or a widow. Under the Women's Charter, any person who has a carnal connection with a girl below the age of 16 years old, except by way of marriage, is guilty of an offense. The Penal Code provides that the offense of statutory rape is made out of if a man has sexual intercourse with a girl, even with her consent, if she is below 14 years of age. This means that a child below 14 years old cannot legally consent to sexual intercourse. The Children and Young Person Act 2001 is an act to provide a welfare, care, protection, and rehabilitation for children and young persons, to regulate homes for children and young persons, and to consolidate the law regarding the children and young persons. Similar to Malaysia, offender in Singapore is liable for sexual offence against child if found sexual assaulting against children, having possession of children pornography, or exploiting minors, and many more. Firstly, on sexual assault by penetration of minor under the age of 16, provided under Section 376A of the Penal Code, offender can be fined or jailed up to 10 years or more if the offender is found guilty for performing sex with a minor under 16. Legally, a man cannot be a victim of rape, provided under Section 375 of the Penal Code, where a man cannot be a rape, as there must be a penetration of vagina in order to be sued for rape. A woman technically cannot commit rape, as Section 375 only applies to male offender. However, a woman who commits sexual act against a minor can be convicted under Section 376 of the Penal Code, provided that if they have used a part of their body or an object to penetrate another person's vagina or anus without the person's consent. In any case, if both parties who perform sexual acts are constituted as statutory rape if the victim is under the age of 16 years old. Generally, a child is not capable of giving consent. If such an act is performed against a child, it cannot be used as a defense and is deemed to be rape or unlawful sexual penetration, liable to imprisonment for a term up to 20 years plus fine or caning. Under Section 377 of the Penal Code provides that if the offender is above 21 years old, he cannot claim that they mistakenly believe the person was not underage as a defense. However, if the offender is below the age of 21 years old, he may use it as a defense as a charge of offense under Section 376B or 376C. It is punishable if any person is found guilty for commercial sex if the person under the age of 18 years old in Singapore under 376C of the Penal Code. However, if the offender is a Singapore citizen or a permanent resident and the act was performed or done outside of Singapore, the offender can be charged under Section 376C of the Penal Code. If the offender at the age of 21 or above has previously met a child under the age of 16 years old or has been contacting with the intention of having sex, he can be charged with the offense of sexual grooming. Similar to Malaysia, if the offender is found selling or exploiting a child is also an offense. Any person who is caught exploiting a child or young person sexually will be guilty under Section 7 of the Child and Young Person Act 2001. Even if the offender only attempts to commit, he will also be guilty under Section 7 subsection B of the Act. Offender who is guilty of selling any person under the age of 21 years old with the intention of prostitution or any unlawful immoral purpose and has the knowledge of the purpose can be liable and punishable with the imprisonment of a term which may extend to 10 years with a fine of Section 372 of the Penal Code. Offender can also be liable under Section 12 of the Child and Young Person Act 2001 for trafficking children. However, if the person who is buying a minor with and for the intention and has a knowledge of sexual purpose for such as prostitution, it is punishable under Section 373 of the Penal Code.
So I will now compare the punishments between Malaysia and Papua New Guinea. So the punishment provided under the Sexual Offences Against Children Act 2017 includes imprisonment, whipping, and fine. The term for imprisonment, the number of strokes carried out by whipping, and the amount of fine vary depending on the severity of the offences convicted under the Act. The maximum punishment imposed is imprisonment not exceeding 30 years and whipping not less than 6 strokes. In Papua New Guinea, the law that regulates sexual offences against children is covered under Divisions 2A and 2B of the Criminal Code Act 1974, which are added with the enactment of the Criminal Code Sexual Offences and Crimes Against Children Act 2002. Division 2A covers sexual offences against children, while Division 2B covers commercial sexual exploitation of children. The punishment for any offences committed against the two divisions is imprisonment, with the maximum punishment being life imprisonment. Life imprisonment is imposed for offences committed to a child under 12 years old or presence of abuse of trust, authority, or dependency, carried out by the offender. These offences include sexual penetrations, obtaining services of a child prostitute, and offering and engaging a child for prostitution. However, Malaysia provides a wider scope of protection for children than Papua New Guinea. For example, regarding abuse of trust, authority, or dependency, the law of Papua New Guinea, which is Section 229E subsection 1, only covers sexual penetration and sexual touching of a child between 16 to 18 years old. On the other hand, Section 17 of the Sexual Offences Against Children Act 2017 covers all offences under the Act, and the age of the child is irrelevant. The implementation of life imprisonment for certain sexual offences against children does seem to provide better justice for the victims, protect society from the offenders, and deter society from committing such crimes. Nevertheless, the 2016 report shows that 70% of children in Papua New Guinea suffer physical abuse and 50% face family violence, which includes sexual abuse. There are a number of reasons why child abuse cases remain high in Papua New Guinea. 1. Law enforcement are weak and inconsistent. Moreover, police and prosecutors rarely pursue investigation of criminal charges against people who commit family violence, even in cases of repeated rape, and instead prefer to resolve such cases through mediation or payment of compensation. This creates a gateway for offenders to escape from being punished and undermines the effectiveness of the law. 2. Physical and sexual abuse against women and children are normalized by the society. To make matters worse, the government does not attempt to raise awareness of children's rights and put an end to cultural customs that are detrimental to the children. 3. Services such as safe houses, qualified counselors, and rehabilitation centers are greatly lacking, which is burden to victims who require assistance. On the other hand, under Sections 26 and 27 of the Sexual Offences Against Children Act 2017, the court may order a period of rehabilitating counseling on the offender and implement police supervision on the offender after the expiration of the sentence passed on him. Although rehabilitating counseling is not much of a success due to an increase in suspects who commit repeated offences of child abuse, the government continues to focus on rehabilitation as a method of combating sexual offences against children. This method is to ensure abused children will not repeat similar offences in adulthood. Besides that, the Malaysian government is focusing on raising awareness through education, counseling, and workshops, which will educate the public to perceive sexual abuse against children as inhumane and should not be accepted by society. To sum up, Malaysia may not have severe punishments for sexual offences against children, but it does implement more effective ways to reduce such offences from becoming widespread. By focusing on rehabilitation and educating the public, people will be more aware of children's rights, and future sexual offences will less likely be committed by abused children, putting an end to the cycle.
Child pornography is material that visually depicts sexual conduct below a specific age. It's not only pedophiles who indulge in such heinous and abhorrent nature of crimes. Child pornography problems have been existing a number of years, but it has grown prominently and became easily accessible from the time internet became a necessity for mankind. Victims of child pornography are immediately harmed during abuse and creation of the image. However, they will turn to perpetual harm when their distribution on the internet spread or continues. There is no clear law that defines and prohibits child pornography in India. The Indecent Representation of Women Prohibition Act 1986 is limited to visual representations, leaving out audio materials and simulated images, which are covered under international law. Besides, this act does not include boys. Male children were equally vulnerable to sexual exploitations. One of the example cases is Freddie Pitts, a 76-year-old man was arrested for sex crimes against young boys, some as young as 3 years old. Besides, although the Information Technology Act 2000 covers digital and electronic videos, it does not include the provision of child pornography. The term of child pornography had replaced by the terms sexually explicit act in latest draft of the bill. According to National Crime Statistics, there are nearly 300 children get sexually abused every day in India. Moreover, due to no clear provisions and definitions, Even though watching child pornography is illegal in India, it is still hard to enforce. Nitish Chadan, a founder of the cyberblog India, stated that there are at least 50 WhatsApp groups that found within 4 days, to which hundreds of Indian users are subscribing and sending child sexual abuse material on. Compared to Malaysia, Section 4A of SOCA 2017 has defined child pornography clearly. The representation not only including the visual, written, and also audio and images. The law does not just include a child engaged in sexual activities, but someone appearing to be or operating a child as well. Other than that, Section 5 to Section 10 has prohibited making, distributions, watchings, and accessing child pornography. It should be noted that animations or drawings which appear to be realistic depictions of minors engaged in sexual activity will fall under this definition as well. Japan currently has no regulations on pornographic material if it is in the form of illustrations, anime, or video games graphics, even if it depicts sexual abuse of children. This influence in the culture of love-high effects is the emergence of an environment where children are entangled by adult sexualities. The U.S. State Department's 2013 report on human rights practice in Japan labels the country an international hub for the production and trafficking of child pornography. It cited Japanese police data showing the number of child pornography investigations in 2012 rose 9.7% from a year earlier to a record of 1,596. The cases involved 1,264 child victims, almost twice as many as in the previous years. There may have conflicts with the freedom of speech while prohibiting virtual child pornography. In free speech coalitions, the Ninth Circuit held that absent some census showing that computer-generated images cause the same harm to children as real child pornography. The fact that virtual child pornography lacks social value is not enough to label it as unprotected speech. However, there are two significant problems. First, if the Supreme Court labeled obscenity as unprotected speech, certainly virtual child pornography should be considered as well. Second, it's about the harm to the children. First of all, when pedophiles viewing the child pornography, they doesn't care about whether the pornography is real or virtual. They may want to commit similar acts on real children. Secondly, pedophiles often use the child pornography to seduce those other children into sexual activities, in part relying on what the court said in Osborne. When a child views a video of a similarly aged child engaging in sexual activity with an adult, the child sees the activity as being acceptable. Moreover, it can be used to promote the market for child pornography, the destruction of which is something that the court specifically recognized as a legitimate interest in Osborne and Ferber. The Statutes of Child Pornography Prevention Act of 1995 would encourage people to destroy all forms of child pornography, thereby reducing the market for the material. Picture that looks like child engaging in sexual activities can be exchanged for actual child pornography, and thus, by limiting the production and distribution of images that appear to be of children having sex, SOCA helps reach the market of all child pornography. Internal broadcasting systems, the court state that fundamental principles of legislation is that Congress is under no obligation to wait until the entire harm occurs but may act to prevent it. Consequently, the fact that virtual child pornography doesn't record a crime or create a victim doesn't imply that there is no causal links between virtual child pornography and the sexual abuse of children. The SOCA helps prevent future crime from occurring.
One of the flaws the Sexual Offences Against Children Act 2017 omitted to address was underage marriage. Although Sexual Offences Against Children Act has introduced new offences against children, namely child grooming and child pornography. However, the act did not touch on child marriages. Under laws for Muslims, the marriageable age for women is lower than men. Section 8 of the Malaysian Islamic Family Law Act of 1984 clearly states that minimum legal age for Muslim boys to marry is 18 years old, while it's 16 for a Muslim girl. Younger couples are allowed to marry with written permission from the Sharia court after both sets of parents have
put in an application to formalize their nucleus. Without permission from the Sharia court, the couple has committed an offense and shall be punished with a fine not exceeding 1,000 ringgit or a jail not exceeding 6 months or both. For non-Muslims, the legal age of marriage is 18. Non-Muslims girls are permitted to marry between the ages of 16 and 18 with the consent of the Chief Minister. This is clearly stipulated under Section 8 of the Law Reform, Marriage and Divorce Act 1976. Though the law on the issue seems clear and it can be abused if no proper action is taken. The Law Reform Marriage and Divorce Act of 1976 stipulates that under no circumstances can the marriage of non-Muslims below 16 years old be legally approved. Crucially, Muslims are exempt from this act. Hence, in practice, there is no written absolute minimum age for them. Due to that, children are being forcibly and suddenly exposed to sexual acts before they are physically and emotionally ready. The girls are at risk of bearing children before their bodies are physically mature for it. Although an approval from a Sharia court judge or a chief minister is required to allow a child marriage, nevertheless, this reliance on this discretion of judges has raised many concerns and worried many people because based on the approval rate of child marriages applications according to the JKSM data in 2015 was 81% child marriage applications. The approval may become because of this, approvals may become a mere procedural process. Though there are laws, nevertheless, it can be easily manipulated by devious parents to marry off their daughters. When sex acts or abuse have occurred with the consent of both parents, the court won't have any power of decision on the matter, but rather to agree to the marriage. The court should be more willing to exercise its powers and decide by themselves the best course of action to protect the child from being sexually abused behind the curtain of marriage rather than submitting to the family's pressure, as it is the role of the court to protect people even from those closest to them. Many solutions are recommended. The first step to be taken is on reforming the approval process by allowing objections by the child's relatives or a government officer above a certain rank in the welfare department or a social worker with demonstrable grounds for objection. If there is the slightest hint of sexual abuse and unwillingness on the part of the child, the judge or the chief minister should not hesitate to throw out the application and order a police investigation instead. However, in the long run, maybe state heads and the sultans discuss and apply some pressure on raising minimum age for child marriages, introducing mandatory education on the effect of child marriages. The government should consider these proposals and meet agencies on the issue and find ways to protect the interest and safety of our children. Because an underage marriage has lasting consequences, especially for the victim. When women married in their teens or earlier struggle with the health effects of getting pregnant very young. The welfare of the newborn is also uncertain. Underage marriages could lead to domestic violence, child sexual abuse, and even marital rape if no concrete steps are taken. So, now, in our conclusion, we are going to help you digest all the information you have been fed in this presentation about Sexual Offences Against Children Act 2017, or in short, as we call it, SOCA. So, first, sexual abuse cases against children is not an issue many people would want to read about or acknowledge, yet it's something that does happen in Malaysia. While the Malaysian Penal Code does have some limited protection for minors, such as Section 375, which prohibits the rape of a minor, or Section 377 that prevents anyone from causing a child under 14 to commit indecent acts. It's also really an old law, and that is wasn't enough to protect minors, and that was one of the reasons the government decided to draft a new law specifically dealing with this issue in the form of Sexual Offences Against Children Act 2017. It is also worth mentioning that this was a rare time in which the bill proposal for the law received unanimous support from both sides of political divide when it was tabled on Parliament. Lastly is the call to ban child marriage in Malaysia, most recently made in Parliament when a lawmaker submitted a proposal to amend the Sexual Offences Against Children Bill 2017 to include a ban on child marriages, has met with some resistance and remains unacted upon as such. We wish that more people will raise their voices in order to end this dangerous phenomenon and protect our children. Now, the soccer is not a bill anymore, it's an act. However, we can still amend acts of Parliament if we combined all our voices for something that needs to be protected. Thank you.